May it please the Court, I appear with my learned friends Nigel Jones, KC, Lisa Freeman and Lawrence Page for the appellants in this matter, and my learned friend Lord Panic, KC, leads a team including James Goldsmith, KC, Andrew Scott, KC, Jonathan Schwartz, Abra Bombas, James Ruddle and KV Krishna Prasad.
That's quite a list.
That is quite a list. There are some complex issues. What I'm proposing to do, with your Lordship's permission, after some brief introductory comments, is to address the following matters. Firstly, the relevant factual matrix. Secondly, the revenue rule and its rationale. Thirdly, the powers that are available to the SCAT as a tax authority and as a litigant. And then finally, to deal with each of the three grounds of appeal in turn. Now, my lords, there was a moment briefly in the Court of Appeal where peace broke out, and that was when my learned friend Lord Panic said in terms, Lord Lawrence Collins knows a thing or two about this subject. We respectfully agree. It's therefore interesting, we say, to consider at the start of this appeal what Lord Collins's view might be on the question of whether or not the revenue rule applies to the fraud alleged in this case. Your Lordships will find Lord Collins's article in the Authorities Bundle, page 5491. And it's a case note concerning the Sinico judgment of the European Court of Justice. The Sinico case concerned a claim by HMRC in the UK courts to recover damages for conspiracy arising from an alleged MTIC fraud, where the defaulting traders in question were UK taxpayers, but where the defendant was a Danish company. And so what HMRC did was they brought proceedings in the English courts against a Danish company seeking to recover damages for unlawful conspiracy. So unlike this case, this was a case where HMRC decided to play on home turf. Now, the Court of Justice of the European Union inclined to the view that the claim would not fall outside the scope of the Brussels regulation, but left the final decision on that issue to the referring court. At page 5492, second paragraph down, Lord Collins says this: "This is a surprising result. The test for what amounts to a civil or commercial matter has no direct equivalent in the English conflict of laws, but the rule in England is that the English court will not allow a claim for the direct or indirect enforcement of a penal, revenue, or other public law of a foreign state. And no doubt, if an English court were considering an action by, say, the Irish government in a similar claim against an English company, it would regard the claim as being an inadmissible claim for the indirect enforcement of foreign taxes." Now, in a carousel fraud, of course, it's usually the persons other than the direct taxpayer who will be pursued, because the clue is in the name. The person who has incurred a tax debt has gone missing, leaving a tax debt behind. Other persons who are not the direct taxpayers are then alleged to have had knowledge or means of knowledge of the fraud, which either then justifies a separate tax decision against them to refuse, for example, a reclaim of input tax in a VAT setting, or a separate civil claim, as was engaged in Sunico. Here, however, SCAT has decided not to bring its claim in the Danish courts. It's nonetheless brought a claim directly against 6 what I will call WHT applicants, that is, withholding tax applicants, directly. So 6 of the defendants in our claim are persons who were WHT applicants. But it's also brought a claim against a host of other persons, financial advisors, custodians, etc., on effectively an accessory liability basis. What we suggest with respect is wrong is to seek to airbrush the role of the WHT applicants from the history of the case, to the extent that's done perhaps in my learned friend's paragraph 4 of his written case. Those are the persons who, on any view, have directly received refunds of withholding tax and who are being pursued for their return. That claim necessarily turns upon the prior annulment of what would otherwise be a binding and applicable public law decision taken by SCAT that a given sum of income tax should be refunded to a specific applicant. Indeed, the fact that the SCAT has been obliged to reduce the quantum of its claim to reflect any recovery of overpaid tax from the WHT applicants confirms the indirect nature of the enforcement of the overpaid tax. So, on what basis, in the light of Lord Collins's view, could it be said here that the revenue rule should not apply? Well, of course, one option might be to suggest that it's not a direct claim to recover income tax against the taxpayer. That's not right, we say, since, as I've just said, the claim is in part made directly against WHT applicants who are themselves the recipients of the refunds. They were initially determined by SCAT to be eligible for those refunds. SCAT now considers the refunds were wrongly made. It challenges the eligibility of the refund claims. We say that the determination of that issue necessarily involves a detailed analysis of the criteria for eligibility, since SCAT's claims cannot succeed if in fact the refund claims were indeed eligible. In any event, we say the revenue rule clearly encompasses both direct and indirect claims. SCAT has also accepted, we note, that claims in negligent misrepresentation against the ED and F man defendants who were not taxpayers would be caught by the revenue rule. The next argument might be that somehow fraud is different, so that there is a basis for treating claims in fraudulent misrepresentation separately from claims in negligent misrepresentation. But SCAT has eschewed any suggestion that different rules apply to fraud, and we say it was right to do so, based on the endorsement by the House of Lords in the Government of India case of the reasoning of the Irish judge Kingsmill Moore J in Buchanan and McVeigh. The carousel fraud in Sunico was also a fraud case, but that did not stop Lord Collins opining that the revenue rule would apply. SCAT say this is a fraud case, but it is a claim of an alleged extractive fraud on the revenue. I'm just pausing there. Whenever I say alleged fraud, obviously my clients contest the allegation that there is fraud. If I occasionally slip into describing it as a fraud, please could it be taken as read that that isn't any admission, it's simply...
Well, we're here to analyse the claim made. You accept that?
I accept that, no.
Yes, and so the claims haven't been proven. So we can speak about fraud, but on the understanding that it's an allegation.
Thank you very much, my Lord. I'm coming on specifically to the pleading case shortly. Naturally, therefore, we say that the point is that pleading of fraud should not make any difference to the application or non-application of the revenue rule, because it hasn't in Buchanan and McVeigh as applied in the Government of India. Next, we come on to what we submit is the kernel of SCAT's case. It's said that by looking solely at the pleading case, what is alleged here is fraud, and the conditions for a valid refund of tax therefore never existed. It's therefore said there is no outstanding tax liability to be claimed. We have three fundamental difficulties with that. First, we respectfully suggest it asserts what must be proved. In any situation where a tax liability is contested, the parties will argue for and against the proposition that the criteria for a charge to tax are met. In fact, usually it will be the taxpayer saying, I don't owe any tax, there isn't a chargeable event for tax purposes. But if a tax refund has been made, such as, for example, a payment as payment for a claim of input tax, the battleground will be whether or not the criteria for the refund were met. Secondly, the case law makes clear that the court must examine the substance of the claim, not simply the form. So whilst we naturally recognise that one starts with the pleading case, one can't simply plead that this is not a tax case and expect the court to accept that without quibble. We say it wouldn't require the assembled legal skill that SCAT here deploys to plead a claim without any direct reference whatsoever to the recovery of a tax debt. But in the words of Lord Watson in Huntington and Attrell, for my Lord's note at page 2036, the fact that the claim is brought in the shape of a civil suit makes no difference. What matters is substance, not form. Thirdly, we say an indisputable fact here is that SCAT has, in the exercise of its legislative powers, made refunds of income tax to a number of WHT applicants. Those public law decisions were valid until rescinded. Indeed, SCAT has purported to rescind some of those decisions only in the course of its pleadings in this case. But the claim therefore necessarily seeks to recover tax funds wrongly paid out. To the extent that it's necessary here to go one step further and say that there must be an outstanding revenue claim following the obituary observations of Lord Mackay in Williams and Humbert, there is one. The claim to recover income tax, which SCAT alleges was wrongly paid out, is a claim to recover input tax. That is an outstanding liability. Indeed, if there were no outstanding claim to recover the overpaid tax, none of us would be here today. If all the WHT applicants had paid the sums demanded back from them, the quantum of the claim against the other defendants would be zero. And that chimes, of course, with the recognition that credit must be given for sums recovered against the US pension funds, the Malaysian pension funds, and so on.
Can I just take you up on your first point? I mean, you say that what is asserted has to be proved and it's contested, and that we have to have regard to the battleground. Now, what do you mean by that?
Well, one has to look at the shape of the claim that has been pleaded against us. One simply can't say, for example, here, there were no dividends full stop, because on any view, the SCAT payment decisions have been made on the basis that there were dividends from Danish companies. The question is not so much were there dividends from a Danish company that were paid out, it was who was eligible to claim any refund of the tax.
So it's not so much the battleground, it is the analysis of the claim.
Yes.
So the defence or potential defence is irrelevant in this context.
The defence provides context, but I accept that one must take the pleadings at face value, and this isn't a mini-trial.
But no, it's the pleadings in the claim, not what is said in the defence.
And I shan't be taking this court to anything in the defence other than the passing reference to the fact that we've raised it.
It's just I wanted to understand what you meant by the battleground. Thank you.
Your Lordship, with respect, is quite right. My point is that substance must triumph over form. One simply can't plead this is not a tax case and expect.
That is your second point.
It may be that I have overstated the first one. So where we end up, we say, is that the key issue was identified succinctly by Mr. Justice Andrew Baker at first instance, when he said that the key issue was whether SCAT's unsatisfied claim to recoup what it paid out by mistake is to be regarded for the purposes of Dicey Rule 3 as a revenue claim. Now, we say there's no distinction in principle between a claim to recover tax that is due and a claim for repayment of tax that has been wrongly paid out. Indeed, one need think only of a classic VAT carousel fraud case to know that output tax and input tax liabilities are often flip sides of the same coin. HMRC will frequently seek to reclaim input tax wrongly recovered, including when pursuing an emptic fraud, since that is how the money is extracted in that type of fraud. Similarly, the excise duty regime can involve claims for excise duty drawback. Seeking to recover wrongly paid drawback claims is an attempt to recover the underlying excise duty that has been wrongly paid back. We say it's equivalent that where withholding tax has not been properly accounted for, whether or not the tax authority brings a claim for payment or a claim for refund depends on the nature of the regime. So in withholding tax regimes, one way of operating the regime is to have a deduction at source basis, whereby the company is entrusted with paying the correct amount of tax to a given shareholder and accounts for the remainder to the host state that is charging the income tax.
Well, in an excise duty clawback, that is a situation where the clawback is being made against the taxpayer. Is that right?
So
the carousel fraud, no doubt you'll be expanding on later in your submission.
Excise duty refunds I'll touch on briefly as well, but essentially excise duty is paid in the UK on a first commercial production outside a duty suspense arrangement. If those goods commercially are then transferred to France, excise duty becomes due in France, and it's open to the trader to reclaim the excise duty that they've paid in England.
Yes.
Because the ultimate place of consumption will be France.
But in that context, it is a taxpayer reclaiming something that he is due.
It is, that's correct.
Yes.
That's correct. But if, for example, a claim were brought on that fact pattern, and a revenue chose to sue not simply for the payment of the refund of the claim, but also people on an accessory basis for facilitating through an unlawful conspiracy the refund that was paid, then the facts we say would be analogous to the facts here. The key point is the refund of the tax does not alter the nature of the sovereign act that is being exercised. It's still effectively a de facto enforcement of a tax liability. It's just that instead of a formal assessment of the tax being due, it's a request for a refund that's been accepted and then subsequently the view is taken that that refund shouldn't be paid. With withholding tax as well, you can either have the deduction at source regime that I've just described, or one can have a refund arrangement whereby the tax is transferred to the tax authority and then there's separate requests for refunds from persons said to be entitled under a double taxation agreement or double taxation convention. So where here, withholding tax has been deducted in full, but is then subject to a claim for refund, it's incumbent upon the tax authority to make a claim to recover that refund if they say it's been wrongly accepted. The next point that might be taken against our case is that the revenue rule is obsolete and should not be endorsed by this court. We do say that particular nuclear button has not been pressed by the SCAT in this case. Indeed, at paragraph 7 of its written case, it expressly states that it does not invite this court to depart from previous House of Lords authority. That reflects the fact that the revenue rule is a widely recognised rule of private international law. It's applied in this jurisdiction and is applied in the jurisdiction of our near neighbours. The effect of the revenue rule is to encourage states to agree between themselves through bilateral and multilateral treaties when mutual assistance in the enforcement of taxes will be permitted. And that allows states to bring claims involving tax in their own states with their own judges ruling on their own law. That state can then seek the assistance of its neighbours when seeking to enforce any tax liability that is found to be due. Now, it's also important to emphasise at the outset that whilst in this case we're dealing with a friendly state, member of state of the European Union with whom we were in direct treaty relations for a long time, the revenue rule applies to all claims brought before English courts by any sovereign, and permutations of that have been recognised in the case law. We respectfully suggest that it's for the executive and, where appropriate, Parliament to decide on what basis and to what extent treaties or domestic legislation might take an exception to what my Lord Lloyd-Jones referred to as the almost universal principle of the revenue rule in the Ben Nevis case. For my Lord's note, that's at page 3024. We say that the executive is better able to take into account the extent to which any waiver of the revenue rule should take place on a bilateral rather than unilateral basis.
That really isn't an argument for today, because the only issue is the revenue rule is there. What does it mean?
My Lord, if I've deployed an argument preemptively against a case that isn't being raised, I apologise.
Well, I don't think it's being raised.
It's not being raised.
No.
Can I move on then, please, to the second part of my submissions, which is the factual matrix? For the court's note, that's dealt with in our case, paragraphs 32 to 52, Malone and Friends case, paragraphs 31 to 43.
Sorry.
I'm going too fast, I apologise.
32 to 52 is your case.
32 is ours, 31 to 43 is Malone and Friends. And then
Sorry, your case is
32 to 52.
yes.
My Lord.
What's the Respondent's case?
31 to 43.
Thank you.
And the statement of facts and issues, of course. Now, the present claim is brought by SCAT as part of a very wide campaign to recover funds, some said to be extracted from an alleged fraud on the withholding tax regime in Denmark. At appendix page 1342, behind tab 40, we have a report of the Danish Ministry of Taxation in 2019, confirming to the Finance Committee of the Danish Parliament the measures that had been taken to try and recover those fraudulently obtained refunds. And we see in the second paragraph up from the bottom of page 1342 that the Ministry of Taxation is confirming that the criminal and civil channels serve the same fundamental purpose: to bring legal liability, civil or criminal, to bear for the unauthorised payment of refunds of dividend withholding tax, and to recover the largest sum possible for Danish public funds. SOIC, which is a specialist prosecutorial body in Denmark, and the tax agency, which is SCAT, now have a variety of legal remedies available in cases where SOIC is seeking to enforce criminal liability, which includes, apart from confiscating the proceeds of the suspected fraud, the option to impose sanctions in the form of a fine and/or imprisonment. The tax agency is looking to trace and recover as much as possible of the 12.7 billion Danish kroner via civil lawsuits. At page 1343, we then see halfway down the page that the tax agency has reached so far a minor settlement with 2 US pension funds for approximately 10 million Danish kroner, as well as a major settlement with US pension schemes and a number of associated persons which have collectively agreed to pay 1.6 billion Danish kroner that they have directly or indirectly received as a refund of dividend withholding tax. At the bottom of the page, it said, the legal argument presented in this case is that those who applied and received a refund cannot be regarded under tax law as the legitimate owner of the shares which provided the basis for paying dividends. So it's recognising that a substantial array of civil and criminal proceedings are being taken to get the overpaid withholding tax back in, and the legal basis for that that's being asserted is effectively that the applicants were not eligible for the refunds. Now, those measures that have been taken have included against Mr. Sanjay Shah and the what are called the Sanjay Shah defendants a number of proceedings, both civil and criminal, in a number of jurisdictions. The position essentially is as follows. Mr. Shah has been in detention in Dubai pending extradition proceedings for over a year. The Danish state seeks his extradition to Denmark to face criminal charges under Danish criminal law. The Sanjay Shah defendants have been subject to proceedings in Dubai, which were initially commenced in July 2018. Again, for my Lord's note, that's page 649. They are also subject to separate proceedings before the Dubai International Financial Centre Court of First Instance, or the DIFC, which were commenced in June 2018. And Mr. Shah and his companies are also subject to a range of asset freezing measures, including freezing and proprietary injunctions, attachments obtained by SCAT, criminal restraint orders, and governmental requests under mutual legal assistance provisions. Now, it's part of our case that SCAT is here exercising legislative powers to make refunds of income tax to certain applicants, and I propose now, with your Lordship's permission, to make that good. I propose
exercising legislative powers, or using powers conferred by legislation?
Using powers conferred by legislation.
Yes, yes, thank you.
I'm proposing to look first at the substance of the claim that is brought, and then secondly at the pleaded case. And then finally, I need to address this court on the findings of the validity trial, which, as the court is well aware, was held earlier this year. So, in terms of the substance of the case that has been brought, please could I invite the court to turn to page 180 in the appendix, which is part of the key documents. These are the findings of Mr. Justice Andrew Baker at first instance, which we say have not been challenged on appeal. We start, please, at page 184, at paragraphs 7 and 8. I'll take this relatively quickly, if I may, because I apprehend that the court has 184 of key documents bundle, which I hope is the same as 184 in the appendix.
Yes, the 184 of the key document bundle. You're talking, which paragraph are you?
It's paragraphs 7 and 8 of Mr. Justice Andrew Baker's approved judgment.
I'm on page 184, I think, of the main bundle.
I was told that the key documents bundle was the same as the main bundle. Let me just check.
It's not in fact. If you give us the electronic.
227.
227?
Yes, please.
Did you say 227?
227.
Thank you. 177.
Certainly it's 177 in our electronic bundle is paragraph 7 of the judge at first instance. It's 177.
Sorry, I'm getting lost.
Could I give my Lord's references to paragraphs in the Andrew Baker judgment?
That would be the way to do it. Thank you.
Paragraphs 7 and 8 of his Lordship's judgment, we see that there's a reference to the forms by which applications of withholding tax have been made, how they're completed. They're then sent to the department for approval. The department at the time is managed by an individual by the name of Sven Nielsen. Skat says it received under the form scheme and in error approved and paid thousands of WHT refund claims that were not valid claims, in that the transactions or purported transactions relating to shares in Danish companies underlay the claims did not give the applicants the WHT refund entitlement they claimed. By its claim, Skat therefore seeks the return of amounts it says it was wrongly induced to pay out as tax refunds. In paragraph 11, on the same page, we see that the fraud allegation says at its core that the WHT refund claims in which defendants who are said to have been dishonest had an involvement were bad claims, and that those defendants must have realised that at the time. The primary focus of all of the causes of action said by Skat to arise is the information said by Skat to be conveyed to it by a completed WHT refund claim form and the documents sent with it, and what Skat's accounting 2 department did with that information. It said that misrepresentations were made to Skat and induced the approval and payment of claims. In particular, because of a strong culture in Denmark of presuming the taxpayer's honesty in its dealings with Skat. What we then see at paragraph 17 is a high-level statement of the principles that were agreed between the parties. Please could I invite the court to cast an eye back over that paragraph.
17.
It's paragraph 17.
Yes. I think it's a text that we've read several times in the submissions.
I will be as brief as I can, conscious that
Yes.
the court has certainly read it on multiple occasions. Paragraph 18 then also said it was likewise common ground that if Dicey Rule 20 would apply to claims against the refund applicant erroneously paid, then it would apply equally to claims against those said to be culpably involved in the making of the refunds. And then at page 203, paragraph 76 to 87, page 203 of the key documents bundle. Paragraph 76 to 83. There are some key findings made in relation to the overall tax structure of the Danish Withholding Tax Act. These are essentially the core facts found by the judge.
But when you say found by the judge, were there any, I didn't think he was deciding any facts.
Well, he was, for the purposes of this preliminary issue, he was making the provisional findings necessary to understand the context of the claim.
Were they agreed, or was there evidence on this, expert evidence?
I think they were, certainly in terms of how the Tax Act operates, it was substantially agreed, as I understand it.
I think that's right.
All right.
To the extent, what I haven't seen, I'm afraid, is any ground.
I was just puzzled by the use of the word findings on a preliminary issue.
Well, it was findings of what the foreign law was to enable to understand the claim that was being asserted. And obviously this was all subject to such further findings as may be made in the validity.
What I was about to say, I mean, the findings on Danish tax law was the subject matter of the validity trial, as I understand it. So these aren't findings as such. They are merely, are they not merely just a statement of the basis on which he was proceeding pending the validity trial?
My understanding was that much of this was common ground. The issue that wasn't common ground was whether or not the defendants were persons who were eligible to have made the refunds in the first place. But the actual mechanics of the operation of the Tax Act were not, as I understand it, seriously in doubt. And indeed, the findings that are, I say they're findings, the conclusions that are reached here as to the nature and extent of Danish law is in fact substantially mirrored in the validity trial. Now, the trouble with the validity trial is, of course, we say we shouldn't have been at that stage. But I hadn't apprehended that there were particular concerns about the summary at paragraphs, for example, 76 through to 83.
Well, I don't know if there are. I think what Lord Richards was taking up with you is are these findings of fact in this context? But it matters not. No. 76 to 83. 76 to 83. If, as the court has read these paragraphs thoroughly, perhaps I can just tell you which propositions we derive from those paragraphs. Please.
Firstly, non-resident persons in Denmark are liable to tax on dividends obtained from Danish companies.
Mr. You're going to have to go a lot slower.
I'm very sorry.
Dramatic with the taking note of it.
I'm very sorry.
Non-resident persons in Denmark are...
Non-resident persons in Denmark are liable to tax on dividends obtained from Danish companies at the rate of 27%. And that is a tax on income. The Danish company has an obligation to withhold 27% of any dividend payment and pay it as dividend tax to Skat. A non-Danish person who has an entitlement under a double taxation convention to pay less tax than 27% on income can make a claim for repayment of the difference. And that will be the difference between either typically 0 or 15%. Next, Skat considers the terms of the application for a refund. And assesses them for eligibility with the requisite criteria. It has the power to investigate the application and it can require security as a precondition for payment, pending the outcome of any investigation. The question of eligibility can be subject to an appeal before an administrative appeals body and the courts. His Lordship then examined and qualified at 2 points. Firstly, whether or not there was in fact an underlying liability to the tax, and secondly, the related question of whether or not the objective criteria for a refund were met were contentious issues, and those weren't to be determined at this stage.
I'm sorry about this. Your very first proposition there, can you just repeat it? Because I'm not sure I got it down quite right.
Non-resident persons are liable to tax, so non-resident persons who have received a dividend are liable to tax on dividends obtained from Danish companies at the rate of 27%.
Only non-residents?
No, I'm sorry, my lord's quite right. It would be resident persons. All persons who receive a dividend, as I understand it.
Yes. I was slightly puzzled myself because you were saying non-resident persons in Denmark. So I mean, what you're saying is in Denmark, persons who are shareholders in companies are liable to tax at 27%.
Yes, and it's the company that pays that tax to Skat.
That's point two. The second point, yes. Persons in Denmark are liable to tax on dividends at the rate of 27%.
Perhaps the better way of looking at it would be to say recipients of dividends paid by Danish companies are liable to withholding tax at 27%.
Yes, that's probably better.
And that encompasses both resident and non-resident persons. We're obviously focusing here on non-resident persons because it's the non-residency that gives rise to the eligibility for a double tax convention.
That brings in the DTA.
Exactly.
If I can just clarify another point, you mentioned that Skat had a power to require security.
Yes.
For what?
Security, if, for example, it pays out on a
Oh, I see.
To be for the
What,
repayment
on
of
forgive me.
the repayment of the monies paid out.
Yes, while it's investigated.
After
Oh, I
investigation, SCAT take the view that they're not due.
Yes, I see.
They were not. The repayment wasn't due.
If they need to investigate whether or not the eligibility criteria are met, they can require security to be given to enable them to have more time to investigate it, so that they hold a financial instrument that vouchsafes the tax in the event that the tax isn't due.
They've actually paid out the funds, but they can demand security.
Yes. To enable them to have more time to work out what the correct answer is.
Thank you.
So your contested issues are to be assumed against you for present purposes. Is that correct?
The contested issues are simply not for determination at this stage. What has to be assumed against me, I think, is the way the substance of the case is pleaded against me. So one doesn't look at the defence that says we deny that there was dishonesty or fraud. One looks at the pleaded case and recognises that it is a pleading in deceit, fraudulent misrepresentation, and so on.
So we have to assume that there wasn't an underlying liability to tax, and also that the criteria for refund weren't met, because that is the nature of the claim.
Well, one has to assume, my lord, that what is being alleged against us in substance is that the eligibility criteria were not met.
Yeah, but it goes beyond that. I mean, we also have to assume that the recipients of the money weren't taxpayers at all.
Well, there's a legal issue there, my lord, as to the characterisation of both the claim and the nature of the relationship between WHT applicants and SCAT. We say one can't assume that there's no legal relationship at all, because, of course, the WHT applicants are recipients of refunds, and those refunds have been made under the Danish WHT tax regime.
Yes, but if they aren't taxpayers in the sense that they weren't the recipients of the dividend and they hadn't had any tax withheld from the dividend, one's not really speaking about them as being recipients of a refund, because they never had a tax charge made against them on the respondent's case.
Well, on any view, my lord, there has been a tax decision. And that tax decision was by SCAT to pay what they considered to be eligible refund claims for tax.
Yes. But at the end of it, I'm just trying to analyse, and you'll be taking me to the document, I'm trying to analyse what SCAT's claim is. And my understanding is that the recipients of the monies were not shareholders, did not receive dividends, and weren't taxpayers. I mean, in essence, I think that is the case made against you.
And the way that the learned judge at first instance dealt with this, paragraph 110 of his judgment, was to record in terms that he had not overlooked the fact that in respect of the Solo application, SCAT has pleaded that transactions underlying and generating the dividend vouchers issued by custodians that were submitted to SCAT were manufactured, fictitious or sham. The primary substance of that plea is not that no transactions were entered into, but rather, given their terms and effect, in particular taking the package of transactions as a whole, they did not create such rights or result in such payment or payment entitlement in respect of dividends, as might have qualified the WHT refund applicant to a refund payment from SCAT. And that was something that Mr. Justice Andrew Baker expressly cleared as a statement with counsel for SCAT in the first instance hearing. I can, if need be, take the court to the transcript, but it essentially provides the basis for the conclusion reached by Mr. Justice Andrew Baker that, yes, SCAT are alleging that this was a scheme, a fiction, a sham. The arrangements manufactured a result whereby tax refunds were paid, but that ultimately the substance of the claim was, we have paid out these sums of money to you as a refund of withholding tax, and in fact, with the benefit of hindsight, the eligibility criteria were not met because it said a fraud had induced the payment. And so it's not...
I think the challenge is more radical than that. We're not really talking about a taxpayer failing to meet the eligibility criteria for a particular refund. What I think is being said against you is that you weren't shareholders at all. You weren't in receipt of dividends, and you had no basis whatever to claim a refund of tax, and therefore the monies we've paid out to you purportedly as a refund of tax have nothing to do with tax. I think that's the claim that's been made against you.
That is indeed how it's put, in order to try and...
But I mean, does the judge at first instance at paragraph 110 answer that claim?
With respect, he does, because what he's saying there is it's being said against you that these are a sham, but that is the very issue that will need to be dealt with as to whether or not the eligibility criteria were met. The starting point from the judge at first instance was very much, this is a situation where SCAT has in fact paid and taken public law decisions to pay refunds of tax. And the question then is, can SCAT recover that overpaid tax by way of this claim? And therefore, my learned friend's case, and the way he seeks to put it, seeks to obscure, if I may say so, without being pejorative, seeks to obscure the very important first stage in the analysis, which is that there has been a public law decision taken by SCAT to recognise the validity of these refund claims, which they subsequently seek to annul or rescind. And it's the action of annulment or rescission which then brings into play the allegations of fraud.
Yes. Well, I see that point. That what happened in the process is public law decisions were made. On further investigation, they've been rescinded, and that provides the context for their claims. But you'll be expanding on that, because that's an integral part of your case.
It is. Thank you. I'll be taking the court through some sample documents, albeit briefly,
Thank you.
To show you how it's arranged. Now, next, in terms of how the case in substance is being put, I should add, by the way, it's paragraph 81, subparagraph Roman 7 of Mr. Justice Andrew Baker's judgment. And key documents, top of page 205. He says, in terms, acceptance and payment by SCAT of a WHT refund application is therefore an acceptance of the applicant as a taxpayer pursuant to the WHT Act, an agreement to pay and payment of a sum of money to the applicant qua dividend tax refund. And I hope that's the submission I've just been seeking to encapsulate. It is in fact reflected in a conclusion reached by the judge at first instance.
Yes. Yes, you're founding on the initial decision that was eventually rescinded.
Yes.
Yes. Thank you.
Now, secondly, we say we have the pleaded case of the SCAT in substance. If my lords would be kind enough, please turn to page 1120 of the bundle. This is part of a further information provided by SCAT, dated 6th of May 2020. The tab number is tab 28. Tab 28, page 1120. We see at paragraph 4 that the legal basis in Danish law for SCAT's power to make WHT refunds is as follows.
This is a question that you've asked, and you get the response. Yes.
We say, what's the legal basis for the power? The power is then identified by a series of provisions of Danish law, double taxation treaties, and so on. And those double taxation treaties have been incorporated into Danish law, which otherwise has a dualist approach to international law. And we see paragraph 4.6, section 69b, subparagraph 1 of the Danish Withholding Tax Act provides that if the requirements of that section are met, then a WHT refund must be paid within 6 months from the receipt by SCAT of a claim for payment. The said Act is taxation legislation for the purposes of Section 1 of the Danish Tax Administration Act. Should the court wish to see the underlying Danish law provisions, they can be found starting at page 1706. Section 65 is page 1713, and section 69B is at page 1725. But those provisions have been more than adequately summarised in our respectful submission in the decisions below.
Thank you.
Anyway, this is the respondent's case.
That is the respondent's case. Thirdly, we have some sample documents which help us put some flesh on the bones. A sample application for a refund can be found at page 1273, and that is tab 37. Starting, please, at 1273, we see a form that has been, a letter that has been sent by AccuPay, no longer in these proceedings, enclosing a series of documents. One, a claim for relief from Danish dividend tax, and the form, rather. Secondly, a power of attorney. Two, original dividend credit advices, and then one certificate of residence provided by the Inland Revenue Service in the United States. Page 1274. We see the claim to relief. This was part of the form scheme that Denmark operated. And you'll see that the full name of the pension plan is included as the beneficial owner for the purposes of claiming relief. The reason why it's beneficial owner is because it's the beneficial owner that has the DTA entitlement to double taxation relief. There's then an address given, and the amount is requested to be paid to a particular bank in Luxembourg. At page 1275, we see an example of a dividend credit advice. And it says, please be advised that we've credited your account for the value date of 12th of March 2014. The payment represents the dividend as shown below. There's then a security name, which is given, so that this reflects the public listed company in Denmark, which has, on any view, made a dividend payment. There's no issue but that public limited companies were making dividend payments. The issue is about who was eligible to receive the dividend payment and whether or not that entitled them to a refund. There's then a stock exchange number, stock exchange daily official list, the CEDOL. There's an ISIN, which is an International Securities Identification Number. There's a pay date, number of shares, gross dividend, tax identified, and then the net dividend. And it's been signed by Mr. Shah of Solo Capital Partners LLP.
The beneficial owner shown on the application is not a shareholder in the security.
The beneficial owner is pleaded not to be a shareholder, and that is a contested issue in due course as to whether or not that's right. But yes, it's pleaded against us that the pension fund is not a shareholder, owner. I don't think it's any longer pleaded against us that the beneficial interest is relevant, because that particular subsidiary argument was abandoned shortly before the Court of Appeal. And I'll take my lords to the pleading where I make that good, that there was, whether it's a concession is a moot point. But
the pleaded case against you is that there was no shareholding in the company in respect of which the claim was made.
That is the pleaded case.
Yes, thank you.
Yes. Could you remind me, I'm sorry, the ISIN, what is that?
That's an International Securities Identification Number.
Thank you.
So that is a unique code which is assigned to a particular security that is issued and enables, I think, the financial markets to verify transactions. So each of these transactions, as it happens, was reported, well, it was cleared, and custodial services were used from the UK. So these transactions were reported to the Financial Conduct Authority, and that's pleaded in our defence. At page 1276, there is a dividend credit advice, which is in similar terms, but relates to a different public listed company in Denmark. In all other respects is much the same. The power of attorney is at page 1277. And the IRS certification of the status of the pension fund, US pension fund, is at page 1278. Now, at some point around May 2016 or so, SCAT started refusing applications that were made for refunds of withholding tax from US pension funds. And one sees that at page 1283, behind tab 74.
12?
Sorry, 74 is wrong. Behind 38.
So what?
Page
1283, was it?
Page 1283.
Thank you.
And halfway down that page it says, on 25th of May 2016, SCAT rejected ARIA's request of 24th of August 2015 for a refund of withheld dividend tax. During the case processing, SCAT has asked ARIA for further documentation. However, ARIA has not responded. Now that page forms part of what I've called a provisional decision taken by SCAT, which was intended to revoke previous repayments and to request that repayment be made. As to the provisional decision itself, it starts at page 1280, again behind tab 38. It's a decision dated the 24th of March 2017, and it says in the first paragraph, SCAT proposes that the pension plan repays the previously refunded dividend taxes, giving a total. The background for SCAT resuming the processing of these requests is that SCAT has obtained information about ARIA from the IRS in the USA. And on this basis, SCAT finds third paragraph up from the bottom.
I'm sorry, which page are you on?
Page 1280. So third paragraph up from the bottom. Yes. Having referred to information obtained from the IRS, SCAT finds that ARIA has not had the capital basis to buy or own the shares stated in the requests, that the dividend relating to the shares stated in the request has not been received by ARIA, and that the refunded dividend taxes have not been received by ARIA. SCAT thus finds that ARIA did not have the required capital to make the investments, cannot therefore be the beneficial owner of the Danish shares. Hence, ARIA does not meet the conditions of getting a refund. SCAT therefore refunded the stated dividend taxes to ARIA on an incorrect or wrongful basis. SCAT therefore reclaims the previously refunded dividend taxes according to the rules stipulated in section 69B1 and essentially is relying upon the terms of Article 10 of the Double Taxation Treaty as well. At page 1284, a series of requests for refunds are set out in tabular form, and it confirmed which documents had been submitted to the authority. At page 1285, there's confirmation of the information received from the IRS. 1286 contains a recital of the Danish law provisions that are being relied upon. And then page 1287 sets out the legal basis for the decision. And the legal basis for the decision is identified as a mixture of domestic Danish tax law and the double taxation provisions. At page 1290, there is a proposal that that ARIA repay the refunded dividend tax totaling a given sum.
Where do we see this?
Top of page 1290.
Top, thank you.
And the basis for that decision is then set out. It said ARIA cannot be the beneficial owner of the shares on which they've received withheld dividend tax. SCAT's therefore refunded the stated dividend tax to ARIA on an incorrect or wrongful basis, and it doesn't meet the conditions for the refund. So again, that tallies with the way we put the case, which is, yes, they're saying you weren't the beneficial owner, you weren't entitled to the refund, and the reason why you weren't entitled to the refund was you're not properly to be construed as having the entitlement to the refund. Now, ARIA was given the opportunity to comment on that. See page 1291. If ARIA simply agreed with the decision, then nothing further would happen and it would become final. If it disagreed, it was entitled to make submissions. And we see in the final paragraph, second to final paragraph, sorry, on page 1291, the letter was submitted on the basis of section 19 of the Danish Tax Administration Act. So that supports our submission that SCAT is here exercising statutory powers, or the equivalent of statutory powers under Danish law.
Why are you concerned with this rather than the pleadings?
My Lord, because this provides the necessary context which Mr. Justice Andrew Baker was looking at in order to understand the substance of the claim, which involves an analysis of the pleadings in their proper context. So when Mr. Justice Andrew Baker finds it's a foundational allegation in the pleadings that a series of decisions to make refunds proceeded on an incorrect legal basis, he is in part relying upon the necessary precondition. There were public law decisions to make refunds of income tax, and those public law decisions are then rescinded or cancelled or annulled, and that leaves the way free for a claim to be brought to recover sums that have been, according to SCAT, wrongly overpaid. So if these decisions remained in force, SCAT would face the obvious problem, well, you've accepted that the refunds are due as a matter of your domestic law. How can you go behind that? Well, that's an extant decision. Of course, the ordinary principle that decisions of public authorities are binding unless and until they're annulled or cancelled would apply. So it's a necessary precondition of SCAT's claim that each of these refund applications that has been wrongly paid out is first cancelled, and then a claim to recover is brought.
So all of these, you've shown us a sample as an example, but all of these decisions have been rescinded.
They've either been rescinded by this type of decision, or my understanding is that the pleading that we'll come on to in a moment from SCAT, for the avoidance of doubt, seeks to rescind any that haven't formally been the recipient of a letter. So they're saying in the pleading, for the sake of argument, to the extent we haven't rescinded any particular decisions, they are rescinded. And as I've indicated...
What's been rescinded is the decision you've just shown us.
The decision that's being rescinded is the decision to make the refund in the first place.
Oh.
So it's the acceptance of the application form. These application forms come in, they seemingly fulfil the requirements. An official within SCAT makes a binding public law decision to pay out. That's binding and effective on SCAT until such time as it's overturned or rescinded. And there is then a necessary step as a matter of simple public law principle.
So these administrative decisions, such as this example submitted pursuant to section 19, have not been rescinded.
No, the decisions rescinding the decision have not been rescinded. They remain extant. So this was a provisional decision. It's then confirmed in a final decision I'm about to come on to.
Yes, and your point is simply that in making the decision to rescind, SCAT exercised a statutory power and it was a public law decision.
Yes.
Yes, thank you.
The final decision starts at page 1306.
Just before we go, do you put any reliance on the fact that the provisional decision appears to acknowledge that the ability to make the reclaims is subject to Danish limitation provisions? It's quite a lot of 1290 is taken up with that, and in particular the question about when, under Danish limitation law, SCAT became aware of its claim.
I think that's being deployed defensively to get their retaliation in first, lest it be said that it's too late for the rescission decision to be taken.
Yeah, I was simply asking whether you place any reliance.
Not particularly, because...
As indicating it's a reclaim being made under Danish law.
Well, on any view, the complication is really this, that this provisional decision says we want the money back and this is a reclaim. What then happens is in the final decision, strategy seemingly having changed, we see at the top of page 1321 that SCAT's previous decisions on dividend tax refunds are revoked on the basis of the same findings, essentially. But nonetheless, having previously said that they were requesting that sum, at the bottom of page 1321, SCAT's decision to refund dividend tax thus rests on an incorrect basis. SCAT therefore revokes any previous dividend, but instead of claiming immediate payment there and then, what they say in this decision, SCAT does not collect the incorrectly paid dividend tax refund. This is a change in relation to SCAT's previous draft decision. On behalf of SCAT, the legal advisor to the Danish government will submit a demand notice in which SCAT raises a claim against ARIA for repayment and compensation. And it seems as though SCAT took the decision between the provisional decision and this final confirmatory decision that rather than demand the money there and then, they were going to formally invoke a separate demand notice provision and claim the money that way. However, we then see, top of page 1322, the standard appeal provisions that one sees in any tax decision, certainly in this jurisdiction, where a statutory right of appeal exists, of course, and it's notifying the taxpayer quite properly that they can write to the Danish Tax Appeals Agency within a given time and say why the decision was wrong. So on any view, the slightly complex issue of how payment is to be achieved is postponed, but the core decision, that is a rescission of the decision, is taken here by this document. I haven't gone back through the other part of the document because it largely reiterates the preliminary ruling that was reached, but throws in a series of comments in response to the observations that they received from ARIA or on ARIA's behalf.
Yes, so the document starts on 13.6 and there's a summary in the first paragraph.
Yes.
And in the second paragraph. Yes.
And we see a reiteration at page 1307, for example, my lord, third paragraph up. In this decision, SCAT does not collect the incorrectly paid dividend tax. This is a change. So it's repetition of the conclusion you see at the end. So they're not formally claiming repayment with this document, but a demand notice is then issued. Now, as a matter of fact, and I don't think we need to go into the detail, that right of appeal was then exercised by a number of WHT applicants. For my Lord's notes, that is at page 1502 in AccuPay's submissions and in page 1671 of SCAT's submissions. And they both refer to the fact that a series of appeals were brought before the tax tribunals in Denmark. Now, I've recognised that one must start with the pleaded case against us and analyse it for the substance of the claim that is being brought. I do say that simply because the pleading says in terms there were never any dividends, there was never any tax, can't carry the day, because otherwise it's effectively some form of Jedi mind trick through a pleading where the SCAT will say these are not the claims you're looking for, and that can't be right. What we do say is that one analyses the pleadings and works out what the cause of action is by reference to the context. Then on any view in our submission, Mr. Justice Andrew Baker was right to say the foundational allegation for each of those claims is necessarily that refunds of income tax were made on an incorrect basis, including, I accept, through what is said to be a fraud-inducing payment.
So one analyses the pleading and identifies the cause of action by reference to?
Well, both the pleaded case and the context to the pleading.
Yes.
Now, I will show you in a moment that, in fact, there isn't a discrepancy here, because even though it's not front and centre of the pleading, there is a recognition, at least in the pleaded case, that refunds were accepted by SCAT and refunds were made on the basis of those applications. And so there is a recognition that withholding tax has in fact been paid out to the claimants, but it's said that that is wrong. Could we start, please, with the claim form? It's at page 282, so that's tab 11, page 282. And one sees in paragraph 5, between about September 2012 and July 2015, SCAT received written applications for the repayment of withholding tax from a number of tax reclaim agents based or operating in England, and it then identifies them. then says what each WHT application expressly or impliedly represented, and then paragraph 7, in reliance upon the relevant representations, SCAT accepted each of the WHT applications and paid the substantial sums requested to a bank account held by the relevant agent. Then says the representations were false and the WHT applications were not genuine but fraudulent. Paragraph 9 says SCAT claims damages for the torts of deceit and or unlawful means conspiracy. That, we say, recognises that the foundational allegation is, yes, we paid these sums out, we did so on the basis of fraudulent misrepresentations, and we want the money back. Now, the pleading that operated before the lower courts was what's called the fourth amended particulars of claim, and that is to be found in the supplemental bundle at page 88. I hope my lords have that. The appendix contains the sixth amended particulars of claim, but that wasn't the version of the pleading that was before Mr. Justice Andrew Baker or the Court of Appeal.
I don't think we have a supplemental bundle.
Surprises me.
I have.
Can I just take instructions on that, Lord?
Yes, we do have the sixth amended particulars of claim.
Yes, if necessary, I'll do it.
In the main bundle.
I'll do it by reference to that if I have to.
I thought it was that reference was made to. I'm not aware of us having a supplemental bundle with the fourth.
The reason for referring to a supplemental bundle was that certainly before the Court of Appeal, SCAT said in terms, see page 1664, that it was not inviting the court to consider a pleaded case which was not before the judge. And the difficulty with the sixth amended particulars of claim is it's been amended post the Court of Appeal's decision. So it isn't the pleading that was before the judge, and it's quite difficult with respect to criticise the judge for not understanding a pleading that wasn't before him.
Yes, well, if you're wanting us to understand what was before the judge,
I have a practical issue.
We need to see the fourth amended particulars.
I'm told it was submitted. Perhaps let me. I don't.
When was it submitted?
I think sometime at the beginning of last week. Yes. 30th of June. Anyway.
Just bear with me. I'll check. Because the registry would intimate to us if we received. '30th of June, you say?
Yes. It was, I think, submitted by email at 14:04 on the 30th of June. My lord, I don't wish to waste time with this now.
No, well, if someone behind you could contact our registry and we can have it sent to us.
Thank you. We'll do that.
What you've just shown us at 282 is the 10th amended version.
I'm going to have to go to the 6th amended.
Yes.
Sorry, the claim form. I'm sorry, my lord. Yes, is the 10th amended version.
Well, if we look at the
But if we look at the 6th
claim form, everything that's in purple wasn't in the fourth.
yes,
Yes.
which is another way of doing it. It's just less convenient
Thank you.
presentation. Page 311, please. Can we pick it up at paragraph 3?
So we ignore anything in orange and anything in purple.
Well, say for one point I'll make about the nature and extent of the so-called concession prior to the Court of Appeal. Yes. Page 311. Paragraph 3 confirms that Danish companies are obliged to withhold and pay to the SCAT as withholding tax 27% of any dividend paid to shareholders. It then asserts that paragraph 3b, that, as we've seen from the claim form, between certain dates, numerous applications for refund were received. And then it said certain representations were made. Paragraph 3 says they were made as part of a fraudulent scheme and monies were paid out in reliance upon them. Paragraph 5 at page...
But 3D, I take it, was there from the outset.
Yes, it was.
Yes, there's the allegation of fraud.
The change...
Yes, and it said that they didn't own the shares, didn't receive dividends, and there'd be no tax withheld in respect of them.
That is the pleaded case.
That is the pleaded case. It's quite a significant paragraph, yes.
Well, my Lord, the consequence of that paragraph is essentially we were wrong to think that the eligibility criteria were met. And therefore the sums that we paid out were wrong as a matter of law. We thought these were eligible claims, but they weren't. And the reason it said that they weren't eligible claims was because, in fact, the pension funds did not own the shares in question and had not received the dividends and had not had any tax withheld in respect of such dividend.
Yes.
Now, it doesn't say no dividends existed, nor does it say that the Danish companies in question didn't pay dividends.
No.
What it's saying is you, as claimants, have said that you had received those dividends and that you had paid tax on them, but we dispute that.
Yes.
Paragraph 5, page 314, confirms the structure of the claim. I should say, by the way, obviously the deletion of beneficial in paragraph 3D reflects a point I'll come on to in a moment, which was the so-called change of tack by SCAT just before the Court of Appeal. At page 314, paragraph 5, one sees the structure of the claim and the persons identified by reference to specific categories. So there are defendants who acted as tax reclaim agents and who made the applications to SCAT on behalf of WHT applicants. The next category, 5B, is those defendants who provided credit advice notes. The next category after that is those defendants which SCAT believes were party to the fraud and which either received traceable proceeds paid out or were the shareholders, etc., of entities which received them. And then 5D, those defendants which were themselves WHT applicants on whose behalf the agents made them. So that's the people who received the refunds themselves. They're identified. 5E is then a catch-all of other persons involved in the business of the corporate vehicles and against whom no allegation of dishonesty is made. And particular defendants are there identified. So the claim against them is simply based on negligent misrepresentation. We then see in paragraph 7 and 8 a summary of the provisions of the Danish Withholding Tax Act, which is why I had thought that Mr. Justice Andrew Baker's description of those provisions was not contested. And in paragraph 9, one sees pleaded references to the double taxation conventions at various points. At paragraph 10, there's a statement of how one went about obtaining the refund, which tracks, I hope, the structure that I've shown the court in relation to the application form and the provisional and final decisions. And then paragraph 12, if SCAT accepted an application for a refund of dividend withholding tax, it would make payment of the sums claimed to the account specified in the tax relief form. And we know that the foundational allegation for this claim is that it did so accept those applications to the extent of the total value of the claim. Paragraph 19, page 320, sets out what are called the agent representations, and paragraph 21, page 321, has the custodian representations. Those are the representations that are said to have been dishonestly made. And paragraph 23 then sets out particulars of the falsity of those applications. One sees at page 324,
paragraph 23 are the alleged facts, which we have to assume.
That's the pleaded case against us, as justification for the decision to revoke the previous decision to pay out the refunds. So it said we paid out on a certain basis. It turns out you did not own the relevant shares at the relevant time. Page 324, paragraph 24C, it says, since July 2016, SCAT has issued preliminary decisions in respect of all of the WHT applications. In these preliminary decisions, SCAT annulled its previous decision to accept the WHT applications and pay the requested amounts. Those preliminary decisions invited a response from the relevant applicant prior to SCAT making a final decision, and evidence relied upon by the WHT applicants to establish that they own the shares, received the dividends, and suffered the withholding tax. In the responses received, none of the WHT applicants were able to explain how they in fact managed to acquire the relevant shareholdings, etc., or provided any documentary evidence purporting to support their alleged beneficial ownership or receipt of the shares or the dividends. So I've re-read into that beneficial ownership because that was the pleaded case before the judge. In terms of the changes that were made post the revenue rule trial, one sees at page 327 a more detailed articulation of why it is said the applicants own those shares, had received no dividends, and so on. And much of that, of course, postdates the pleading that was properly before the judge.
Yes, so at the bottom of that page, that's new material which was not before the judge.
Yes, anything that is in orange or pink
Yes.
is going to be material that is pleaded only after both the first instance decision and the Court of Appeal decision.
Yes, so we should properly disregard that.
I'm hoping the court will in due course have a copy of the pleading that was actually before the judge.
But there's nothing in that to which you wish to refer us just now.
No.
Thank you.
Could we then please, I mean, what is essentially being alleged at page 328 and onwards is a series of effectively circular transactions, closed-loop transactions, which are said not to have generated a genuine claim for refund of the WHT, the withholding tax. At page 347, it's only right that I point out...
347.
Page 347, it's only right that I point out how the case of fictitious records or sham was put from the start. And at the bottom of that page, one sees the WHT applications were based on fictitious records of transactions that never occurred, such that WHT applicants did not acquire any interest in the relevant shares prior to the X date and never received the relevant dividends from the Danish companies by the payment date. And/or, it then says, the WHT applications were based on circular transactions that cancelled each other out. At subparagraph 3 on page 348, there's an allegation of sham.
Sorry, where's the further allegation?
Roman 3 on page 348.
Roman 3.
The WHT applications were based on sham transactions which the parties thereby entered into with the common intention to mislead. Now, the deleted passage at page 350 raised an alternative case that if it were wrong and that shares had in fact existed, nonetheless the WHT applicants did not meet the beneficial ownership criteria for the purposes of the double taxation agreements. And that alternative case is the case that SCAT no longer proceeds with. But of course the consequence of that is that the part of the claim that was recognising that the shares did exist but the criteria were not met has been withdrawn by SCAT but was properly before the judge. I'm not suggesting that it makes a huge difference, but it does of course change perhaps the complexion of the dispute that the judge at first instance was being asked to rule upon. And it was only, I think, in November before the Court of Appeal hearing in January 2022 that this amended pleading was flagged up, and it was only, I think, after that date that permission was given and it was served.
So the claim, you say it's at 350?
Page 350's Roman 4 has been struck through in orange.
Yes.
It's that provision that deals with beneficial ownership.
Thank you very much.
Could we then please go to page 370?
You said it's not the shares that exist. It's the claims based on the hypothesis that there had been actual acquisitions of shares.
Yes. In that case, there's an alternative case that is run.
But that's gone now.
That the beneficial ownership criteria was not met.
But the judge had to decide the case against that background.
But that was one of the ways in which the claim was being put.
Yes, thank you.
Page 370, please, my lord.
Thank you.
Paragraph 49 then sets out what are said to be the WHT schemes and how they are fraudulent. I don't think I need to spend too long on that. More importantly, for our case at least, page 395. Paragraphs 52 and 53 deals with mistaken rescission. That's a new subheading that's been inserted, but it's accurate. Paragraph 52, as set out in paragraph 25 above, SCAT decided to accept the applications and make the payments there set out by reason of mistakes induced by the representations. There's then some additional pleading that's new. In the circumstances, SCAT was, alternatively is, entitled to rescind the transactions by which those payments were made. And that makes good the point I made earlier, that to the extent that we don't have the underlying provisional and final decisions of SCAT, this pleading is purporting to do the job of rescinding those public law decisions that sanction the repayment of withholding tax to the applicants.
Well, it's asserting an entitlement to rescind.
Yes.
In the past. So it is justifying something that happened in the past. You're construing it as a rescission of anything else, anything that hasn't already been rescinded?
My lord, simply because the wording is not simply was, it also says alternatively is entitled to rescind, implying, at least on the way I read it, and I may be wrong, that it was actually seeking to belt and braces ensure that any public law decision that had been taken to refund was hereby being annulled, rescinded, whatever.
Well, it's certainly, you're correct that the present tense is used in relation to an entitlement. An entitlement doesn't make a rescission, does it? I may be entitled to rescind a contract, but I may choose not to do so.
Well, it's odd language, isn't it?
It is odd.
The bit in brackets speaks of doing something, whereas the bit which precedes it doesn't.
Yes.
My learned junior has helpfully pointed out that paragraph 54.
54, it has
This dispute becomes happily more crystallised. I hadn't got on
That makes the point quite clear.
It does.
Thank you very much.
I should have gone to that first, probably. The benefit of hindsight. There we are. Grateful to my junior for taking me there more quickly than I otherwise would have done. Page 57. I should say 53 obviously refers to the decisions that I've taken the court to. Hence, my Lord Hamden's point as to why do we need to see the decisions if it's in the pleading? Well, the pleaded case refers to those decisions, and you have the actual decisions themselves for context. 57 then deals with the formal tortious claims, and what then follows is essentially a series of different pleaded causes of actions under both UK law and, or rather English and Welsh law, and Danish law, including inequity. And the next part I would, I think, need to refer to is at page 400. Where one sees a pleaded claim for loss in paragraph 69. And about 6 or 7 lines up from the bottom of paragraph 69, one sees an overall assertion, a vermin. SCAT is entitled to and claims such loss subject to the deductions referred to in paragraphs 106A and 106B below, jointly and severally from each of the alleged fraud defendants who were party to such schemes. So if we then please turn to paragraphs 106A and 106B, they're at page 420. And it's there one sees credit being given for recoveries from WHT applicants in the United States or Malaysia, and the fact that credit will therefore be given Now, I've said it's not appropriate to refer to orange or purple, so I won't refer to the updated figures. But it's obviously a matter of fact that some sums have been received, some substantial sums have been received from certain WHT applicants.
Well, I'm sorry, I'm not sure I've understood what the relevance of the fact that credit is being given for recoveries is.
So that is a situation where the WHT applicants have been sued directly for the recovery of the allegedly unlawful refund claims, and that sum is then used to reduce the level of loss.
I understand the structure, but I'm not sure I understand its relevance to what we have to decide.
The relevance is that SCAT is thereby recognising that their level of loss is coterminous with the amount of tax that's been wrongly paid out. I don't think it's more sophisticated than that as a submission. So
If for any purpose you need the supplemental bundle, it is now with us. Thank you.
very grateful. That does, if I may say so, spare me some effort, because I was proposing to refer to the original validity particulars rather than the updated validity particulars, and I would have required some fancy footwork on my part to equiparate the references. If your lordships therefore do have a supplemental bundle, please could I invite you to look at tab 2, page 65.
Sorry, we're going to the other bundle.
I understand it's just been
It's just
received.
arrived. Yes.
Page
Page 65.
65 it starts at. Could we pick it up, please, at paragraph 3, page 66?
This is the further particulars.
This is further particulars of the validity of the refund applications. It was intended by case management order of Mr. Justice Andrew Baker that the validity trial would be subject to its own set of particulars for the purposes of determining the validity law issues.
So, I'm sorry, so does this post-date?
No, this was
the
before.
hearing we're concerned with?
This was before the judges.
This is back in 2018, I think.
We're going to which paragraph?
Paragraph 3, please, my lord, page 66. Please could I invite the court to read paragraph 3? And then at paragraph 11, page 67, we see reiterated the assertion that WHT applicants did not own any shares in Danish companies and did not receive any dividends. And it then refers to the pleading that follows, and we see at page 68 that that assertion is separated out for the first assertion that they did not own any shares in a Danish company. And we see in paragraph 14 reference is made to the fact that the shares in this case are dematerialised, so they are all held by a central securities depository, namely VP Securities, and that maintains a register. It's then said in 14.3, it is possible for the owner of shares in a Danish company to be different from the person identified in the VP Securities register, for example under a nominee scheme. It's also possible for the owner of shares in a Danish company to be linked to the VP Securities Register through a chain of custodians. Neither of these propositions detract from principles that are set out whether or not the owner of the shares is the person named under Danish law. There cannot be two independent owners for the same share. So the essence of the claim that has been advanced is you have come forward, made these applications and said you are the owner. Upon investigation, we don't think you were the owner, because we don't think you were eligible. And part of the reasoning behind that is that there have been multiple claims to entitlement to ownership of the same shares as recorded in dematerialised form in the VP Securities Register. We then see paragraph 15, SCAT relying on provisions of Danish law in order to establish the ownership position. And it said at paragraph 16 the sellers did not own any shares in Danish companies and therefore could not transfer ownership. Paragraph 17 has an allegation that the transactions were based on fictitious records of transactions that never occurred or circular transactions that cancelled each other out. And then paragraph 18 sets out particulars that the SCAT relied upon at that stage to justify that pleading. We then see a reference to the defence, which had been that Danish tax law, paragraph 19, page 71. The defence was Danish tax law recognises fiscal ownership based on contractual arrangements, i.e. financial derivatives, financial instruments, short of an outright purchase of shares conveying ownership. It then says if that is an allegation that a final and binding agreement has the effect of conveying ownership of shares, even in circumstances where the seller did not own the shares, that is denied. Paragraphs 22 to 28, there are then a series of pleadings as to why it is said the WT applicants did not receive dividends. And it relies upon provisions of Danish law to make that good, and in particular examines the position of Danish securities law and the role of VP Securities and the custodians to make good that claim. And in paragraph 28, page 73, last sentence, it's in the light of the analysis of the contractual arrangements that have been put in place, namely the financial instruments and the financial transactions which Solo, etc. applicants were conducting, that SCAT says, in the circumstances, SCAT infers that the WHT applications were based on fictitious records of transactions that never occurred or circular transactions that cancelled each other out. So what SCAT is essentially alleging is that the transactions that you put in place under what they describe as a scheme were never effective to actually transfer ownership of the shares, and therefore the entitlement to the refund that was submitted with the application forms was never made out. And it's on that basis that it is said the money should be repaid. Paragraph 32 to 34 therefore asserts as a result of that analysis that no tax was withheld from any dividends received by the WHT applicants. That's at page 75. And for that purpose, SCAT relies upon and asserts the relevant provisions of Danish tax law. And in paragraph 34, we see that the circular and/or fictitious transactions did not involve any real shares or any dividends, and no tax was therefore withheld by the relevant Danish companies. So by virtue of the what are said to be fictitious or sham or artificial transactions that have been put in place, it is said that these contractual documents put forward by the WHT applicants didn't have the effect of transferring ownership or giving rise to a dividend that was payable to that person. Therefore, no tax was payable. Therefore, we shouldn't have refunded the tax. That, in a nutshell, is how the case is put. We then see in paragraph 35, that essentially the same allegation is made in part against the ED and F Man applicants. It's also said they did not receive dividends. Why am I emphasising that? Well, because of course the claim against the EDF and MAN defendants has never been asserted to be a fraudulent one. It's always been negligent misrepresentation. And SCAT accepts in this case, because they haven't appealed against the decision, that ED and F Man, the claim against them is caught by the revenue rule, Dicey Rule 20.
That's the concession you mentioned earlier. Is it that was the concession?
Yes, and the judgment below, judgment of the Chancellor in the Court of Appeal, dealt with ED and F Man only in the context of Ground 2. Ground 2, before the Court of Appeal, was the Brussels regulation point, and the extent to which it was a civil or commercial claim for the purposes of Article 1 of the Brussels regulation. That isn't, of course, a live issue before your Lordships. Now, if we could briefly perhaps touch on SCAT's reply to the validity defence.
Could you just help us in relation to the version of what's a claim, was before the charge. We've now got the supplementary one.
Yes.
And can you tell us where that is in the supplement?
Yes, that is.
That's really the one we should be working on.
That's page 88. And one sees at the top of page 88 the colours that are relevant, and they don't include the orange and pink, was it? Orange and pink colours that are in the previous one.
Thank you very much.
So please could I invite the court to turn to page 999, which is part of SCAT's reply to the validity defences. Let me give a tab for those following on paper. 5, thank you. And there's only really one paragraph I wanted to pick out here, which is paragraph 5.5. And it says the WHT refund applicants never received delivery of and did not own shares in the relevant Danish companies, did not receive dividends declared by those Danish companies, no tax had been withheld by those Danish companies or paid to SCAT on their behalf in respect of any such dividends, and they were not liable to taxation in Denmark in respect of any dividend declared by Danish tax companies. Accordingly, they were not entitled to a refund. So what is envisaged for the purposes of the validity trial is therefore whether or not that contention is made out. So the core focus for the issue before the validity trial was applicants saying we had valid claims for refunds and you paid those out and you're not entitled to rescind them effectively, and therefore a claim based on their purported rescission doesn't work. And SCAT saying no, you were never eligible for these payments, you didn't, on proper analysis, receive the dividends, pay any tax on them, as part of a challenge to the underlying assertion of eligibility. And that is something that the validity trial was going to have to determine, and we now know ex post facto that it has determined, at least pending an appeal. The validity trial of Mr. Justice Andrew Baker.
Sorry, the validity has or has not led
It's determined the issue of validity at the moment. It's subject to a pending application. Subject to a pending application, I think, for permission to appeal. Yes, I'm sorry. I need to make clear. The scope of the validity trial was circumscribed to what the relevant legal requirements were for a valid refund claim. So whether or not an individual met those requirements has in fact been hived off to the main trial because it was perceived to require too much work.
Sorry, so I'm getting lost now. Paragraph 5.5 on page 999.
Yes.
I understood that was the point at issue in the validity trial from what you just said, but I think you're saying that now that's not the case.
It was meant to be, and it was meant to cover that, but I've been reminded by my junior, and indeed my leader, who sat through the month-long validity trial,
right,
that the way, in fact, it panned out was everyone realised it was too much of a substantial
So it was really
I was surprised because I thought that was still to come.
Yes. Well, the final decision, yes. What Mr. Justice Andrew Baker has done is, subject to any appeal, set down the rules by which the refund applications are to be judged as to whether or not they were in fact valid.
So that was really dealt with on a basis of expert evidence, I assume.
Yeah. Is that
foreign law?
Of foreign law.
Yeah.
They are, to that extent, factual findings.
They are.
Yes.
And I'm about to come on to that, I think probably relatively quickly. Our point essentially is that, yes, the pleadings say there were never any dividends, there were never any tax paid, but that is necessarily based on an underlying assertion that the refund applications weren't valid and that the transactions that were put in place did not meet the eligibility criteria, notwithstanding a primary decision made to that effect that they were eligible, which then had to be overturned. And so the nature of the claim that's being made here is you did not in fact meet the eligibility criteria and we were wrong to think that you did. And that in a nutshell is why we say this is a tax case, precisely because SCAT has chosen to accept that these were valid tax claims. And anticipating a submission I'll make shortly, this is a situation revenues across the globe find themselves in all the time when there is a refund system. So carousel fraud being a classic example. where a revenue says you weren't entitled to that refund of input tax because you were participating or knew or should have known about a fraud somewhere else in the transaction chain, the revenue is asserting that the criteria for payment of that tax are not met. Now, you can say it's a fraud, you can say, therefore, the objective criteria by which the tax was asserted to be claimed were never met. Therefore, this is not a tax case. But with the greatest respect, that isn't what the way that the courts ever treat, for example, MTIC fraud. And the revenue would get into terrible trouble if, for example, the consequence of the Chancellor's decision below was that by virtue of an allegation of fraud treated as such on the pleadings to be correct, the tax never existed. Why do I say that? Well, because in MTIC fraud, HMRC asserts that by virtue of the fraud, the criteria for a repayment of VAT were never met. Therefore, you never get the VAT in the first place, and that's the justification for it. But if it never existed, and therefore was never a decision that the revenue should be treated as having taken when they refused to accept, having accepted a refund claim, they then want to annul it. The revenue typically wants to rely on statutory powers to annul that decision and to claim through statutory procedure the refund of the overpaid VAT, for example. It doesn't want to have to bring a civil claim before the UK courts to recover that VAT if it can avoid it.
But it has brought conspiracy claims.
Against taxpayers outside the UK?
Well, no, against those in the UK who assist those in the UK in MTIC fraud.
In circumstances...
I mean, obviously the revenue rule doesn't apply, but they have done that.
They've done that in circumstances where that particular...
In fact, one of them came to the Supreme Court.
Total Network.
Total Network.
I'm going to come on to that.
Yeah. But there is a danger in this, isn't there? Because the VAT regime is a self-contained and complex regime. We're not concerned with MTIC or VAT here. I mean, you're going to have to persuade us that the same principles apply, and that's going to require looking at what is quite a complex VAT regime as against what is here a very simple withholding tax regime.
My Lord,
I mean, if your analogy with MTIC fraud doesn't work, it doesn't help you.
That's certainly true. The reason why I'm relying upon an analysis of MTIC fraud, or indeed emissions trading frauds, which is another case, the reason I'm relying upon those is that they show substantial similarities with the way that SCAT has pleaded its case here. Namely, these are a series of self-cancelling circular transactions designed...
But I'm really looking at the nature of the tax regime rather than the nature of the transactions that perpetrated the alleged fraud.
Well, it's both in my respect for submission, because both of them involve an ability to get a reclaim of tax, a refund, which is...
Yes, but that depends on... I mean, you may be right, but it does depend on the particular features of the VAT regime, which is a self-contained and quite separate code.
The only characteristic of the VAT regime I seek to rely upon for its similarity is the fact that one can obtain a refund of tax from a taxpayer.
You have to be a taxpayer, don't you? You have to be a registered VAT trader.
So if one posits a situation where a putative taxpayer, through fraud, has purported to conduct over £85,000 worth of transactions in this country, and at the same time has purported to receive, say, over £150,000 worth of purchases to make those transactions, and has therefore technically incurred a loss. And imagine, for the sake of argument, that each of those transactions is purely fictitious. And that putative taxpayer has persuaded the revenue, by virtue of their purported trading activity, that they deserve to have a VAT registration number. Consequence of HMRC accepting that fraudulently induced registration application will be that a VAT registration number is given to that taxpayer, and that taxpayer will then seek to reclaim input tax against output tax, and on the facts I've posited, that leads to a substantial refund claim by that taxpayer. And assuming HMRC, again through a fraudulent inducement, pay out on that claim, then the position is that HMRC have wrongly recognised a taxpayer connection with a fraudster and have wrongly paid out VAT as tax money to that fraudster. And the key question then is, what is HMRC to do about it? What HMRC will typically do about it is cancel the VAT registration because it was fraudulently obtained, seek the refund of the input tax that has been wrongly refunded to it, and it will seek to deploy the statutory mechanisms available to it to achieve both those ends. What it won't typically do is bring a claim against that fraudster saying, you owe us compensation for damages for treating you as entitled to this tax repayment. Now, if, for example, HMRC...
Yeah, but it doesn't, forgive me, the fact that HMRC chooses to operate in that way within the United Kingdom, it doesn't follow from that the revenue rule would apply to a claim in a foreign court against that particular fraudster.
But no, I think it's highly unlikely with respect that HMRC would be able to bring a claim in a foreign court to enforce the refund of the VAT in those circumstances.
Well, why, if it's a fraudulently obtained VAT registration which has been annulled, why, I mean, it comes back to the same issue, I suppose. Why not?
Well, because the foreign
It's
court...
not operating in the VAT regime anymore, is it?
Well, we're essentially trespassing on the example given by Lord Collins in...
Well, maybe, but that's the problem about trying to argue across from the VAT regime to this. But anyway, I put down my marker on it. That's enough.
My Lord, may I move on, please, to a brief synopsis of the findings in the validity trial itself. And my Lords will find this at page 1195. That's behind tab 36. And obviously our position is this is the trial that shouldn't have happened. It took place over the course of 4 weeks earlier this year. And I'm not therefore proposing to go through the detailed findings because they're all ex post. But I would like to just draw out, please, one or two matters. Firstly, at page 1199, paragraph 3, one finds his lordship saying, case concerns exclusively shares in Danish listed companies that existed at all material times only as a legal construct in dematerialised and fungible form. Paragraph 4 and 5, the court reiterated the broad outline of the Danish WHT regime, and I don't understand, but I'll be corrected if I'm wrong, I don't understand that those findings are materially different from the conclusions that were reached in the revenue rule trial by the judge. We then see paragraph 6 that the entitlement to a refund where it existed was or gave rise to a right under Danish law enforceable against SCAT because the double taxation treaties were given effect by statute under Danish domestic law. There's a reference to the statutory technique by which that was achieved. His lordship then said at paragraph 7 that there was a difference of view between the experts before him as to whether or not the claim for a refund was properly categorised as one in restitution only, or whether it was a claim for a refund of tax, and he accepted the defendant's expert's evidence that the claim for a tax refund is not a restitutionary claim, but a statutory claim under Danish tax law. So the underlying premise behind each of the myriad applications that have been accepted and then rescinded is that that was recognising a statutory claim under Danish tax law for a given outcome. We then see a broad summary of the claim at paragraph 9, and a description of the validity trial itself. That's page 1202, top of page 1202, that the validity trial, as I've indicated, had been restricted rather than being a question of were these claims valid, it was restricted to a trial of preliminary issues to find and determine what are said to be foundational aspects of SCAT's allegations that the tax refund claims it says should not have been paid were not valid claims under Danish law. And that, in a nutshell, we say, is the validity issue.
Sorry, that's separate to the top of
page 1202.
Thank you.
There's then a reference to the length of the trial, 4 weeks, and it says, I've given this judgment the short trial SCAT validity issues to reflect the fact that it is a trial of identified foundational issues rather than the trial upon which I shall have determined in terms the validity or invalidity of any claim. So whilst the pleadings were engaged with, are the claims themselves valid, this was what is the underlying framework by which the validity of those claims are to be judged. That was then going to be determined in the main trial. We see in paragraph 40 that the judgment is considerably longer than otherwise would have been, because he had to find and state the requirements of a valid claim under the Danish Act for a refund of Danish dividend tax. One of those requirements was that the applicant has had a Danish dividend tax liability, so he was also charged with finding when an applicant did have such a liability, not only with determining that the existence of a share sale contract was not enough. So it was intended to define the law for the case that would then be slotted in to consider any individual claim. Could we then please turn to page 1237? And at paragraph 185, top of the page, he refers to the most basic principle of Danish law, being that taxes may only be imposed by primary legislation. And he says the validity issues that I'm required to determine now are ultimately all questions of the proper construction of Danish primary tax legislation. The relevant statutory provisions at the material time were, and his lordship then sets them out. The key findings of the judge, and again, as I emphasise, this is all ex post and subject to an application for permission to appeal, are at page 1262. Starting at paragraph 295.
1252, did you say?
1262, sorry.
62. Thank you.
1262, paragraphs 295 through to 306. And I don't prepare to dwell on those, simply for your lordship's note, those are essentially the key findings as the criteria for tax refunds, relying, for example, on the accruals principle and the fact that the entitlement to a dividend will accrue at the date that the dividend is declared, and so on. And then at paragraph 301, an examination of who the rightful recipients for tax purposes were of dividends. At the top of page 1264, the learned judge summarised the key issue to be determined in relation to any allegation of sham transactions. He said, thus, the effective invalidity allegation against the impugned claims is going to be, I think, that in each case the applicant, it will be said, was not a shareholder for tax purposes when the dividend referenced in the application was declared by the Danish company in question, and therefore had no right to any dividend and no dividend tax liability, and therefore no right to a dividend tax refund. And he's putting that in the context, therefore, of the validity trial. The key issue will be, are SCAT right that the eligibility criteria for the refund application were in fact never satisfied?
You speak about the validity trial, do you mean the main trial?
Yes, it's now the main trial. The relevant answers providing the framework for the legal issues that are then set out on page 1267. Could I now please move on to the third part of my submissions, which is the revenue rule and its rationale. This is covered in our written case, paragraphs 12 to 31, and Lord Panick's written case, paragraphs 50 to 99. I'm going to pass over, if I may, Huntington and Attrell. I'm going to refer only in passing to the case of In Re Visa, which is in Authorities page 4119, which is a judgment of Mr. Justice Tomlin, which is referred to extensively in the cases I am going to turn to. But in essence, the proposition derived from In Re Visa was that the Queen of Holland could not bring a claim to recover succession duty on an estate through the English courts. Could I turn, please, first to the Buchanan McVeigh Authority? And again, I anticipate that the court has had a chance to cast an eye over this decision. and so perhaps I can take it slightly more pacily than might otherwise be the case. It's at page 2279 of the authorities. That's in the Principal Authorities Bundle, tab 8. The facts were that a company director loaned money to his company to buy substantial stocks.
Can you say 2379?
2279.
I misheard you, thank you.
That's the start of the report. A company director, as is, I'm sure the court well knows, loaned money to his company to buy substantial stocks of whisky. The whisky then increased dramatically in value. He then disposed of part of his business on the basis that he wouldn't have to pay excess profit tax, relying on an assurance, it was said, for that purpose. The Finance Act 1943 then made the business retroactively liable for tax, which caused some consternation in Mr. McVeigh's business mind, and it, to use the language of the learned judge in Ireland, called forth the resources of his ingenuity. The relevant stocks were then siphoned off to Ireland, and Mr. McVeigh, again in the words of the judge, sought to snap his fingers in the face of a disgruntled Scottish revenue. Essentially, it was a scheme whereby, in exchange for various warrants, the whisky was provided to a bank. The bank then sold the whisky, and the sums loaned by the bank were discharged by the sale of the whisky by the bank, thus effectively imposing an intermediary between the sales transactions and the company in question. Scottish Revenue subsequently raised an assessment of excess profit tax and appointed a liquidator, court-appointed liquidator, to try and get the tax back. At page 2285, one sees that the judge decided that the scheme was a fraud on the Scottish Revenue. It's halfway down the page. One of the issues was the shareholders, following the geomatic principle, have agreed through a resolution that this trading is fine, therefore there's no problem. It was intra vires. Answer from the court, no, it was ultra vires because it was a dishonest scheme. And indeed, it seems as though counsel for the defendant was quite open about the fact that the intention was to make sure that the Scottish Revenue didn't get their hands on retroactive tax.
One of the oddities is, of course, this is an Irish judgment, but there wasn't at this stage such a thing as the Scottish Revenue. It was the Inland Revenue. But I point that out for what it's worth.
I'm afraid I didn't know that point of detail. I do know.
If you look at the at 2283, the winding up order was made on the suit of the Inland Revenue.
Yes. Well, of course, HMRC now is
now HMRC
is the British Revenue Authority.
Yes, but then page
2286, please. Then one sees second to last paragraph on that page, the issue of recognition of a foreign law being accepted. So the court was prepared to look at Scots law to determine whether or not this was in fact going to be a fraudulent transaction. So recognising a foreign law by itself is not problematic. At page 2287, one sees halfway down the page a paragraph that begins the application of the principle to revenue laws, and there's a citation of In re Vissa, the Queen of Holland decision of Mr. Justice Tomlin, which cites the relevant proposition, and my lords will have seen that. And then there's a reference at the bottom of the page to one of the few authorities I think we don't have in the bundle, which is the William Schultz and Co. case, which is a Scots case, where a claim by the Attorney General for Canada was not recognised by the Scots courts. Turning over the page to page 228, halfway down the page there's a citation of Sydney Municipal Council and Bull, referring to the non-admissibility of a...
I've lost the page.
2288.
Thank you.
Halfway down, Sydney Municipal Council and Bull. I'm showing, my lords, this authority rather than taking you to it as a shorthand for establishing the principles. In that case, there was a claim to recover what would now be council tax. And it was said, the action is in the nature of an action for a penalty to recover a tax analogous to an action brought in one country to enforce the revenue laws of another. The core propositions, the core statements of principle, begin at the top of page 2289. Please could I invite the court to read the first substantive paragraph on page 2289. The second core proposition can then be found at page 2290. Again, starting at halfway down the page, there's a paragraph that begins those cases on penalties. Please could I invite the court to read that paragraph. So one has to examine the substance of the right that's sought to be enforced, and if it involves indirectly the execution of the penal law of another state, then the claim must be refused. At page 2291, there's an extensive citation from the US jurist Judge Learned Hand in the case of Moore and Mitchell. That turns on a perceived potential for embarrassment should the court be ruling in unfavourable terms on the revenue laws of another state. And those issues are then taken into account at page 2292, where the learned judge, Mr. Justice Kingsmill Moore, refers to taxation being originally expressed only through the will of the despot, enforceable by torture, slavery, and death. And he then refers to the fact that taxation these days can either be benevolent or malevolent, depending on its nature. And he says such laws have been used for religious and racial discrimination, for the furtherance of social policies and ideals dangerous to the security of adjacent countries, and for the direct furtherance of economic warfare. So long as these possibilities exist, it would be equally unwise for the courts to permit the enforcement of the revenue claims of foreign states, or to attempt to discriminate between those claims which they would and those which they would not enforce. Safety lies only in universal rejection. And his lordship then examined that if that's the right principle, it's not a question of whether the plaintiff is a foreign state or the representative of a foreign state, although of course that issue does not arise here. In every case, the substance of the claim must be scrutinised, and if it then appears that it is really a suit brought for the purpose of collecting the debts of a foreign revenue, it must be rejected. Mr. Wilson has pressed upon me the difficulty of deciding such a question of fact and has replied on ratio rentus acervi. For the purpose of this case, it's sufficient to say that when it appears to the court that the whole object of the suit is to collect tax for a foreign revenue, and that this will be the sole result of a decision in favour of the plaintiff, then the court is entitled to reject the claim by refusing jurisdiction. He then held on the facts, see two-thirds of the way down, page 2293, that the sole object of this present proceedings was to collect an inland revenue debt, and that was the substance of the claim. There wasn't any other creditor that was going to be served by this. That decision went on appeal to the Irish Supreme Court, where Chief Justice Maguire upheld the decision and indeed the judge's reasoning applying the revenue rule C in particular, bottom of page 2294, and the conclusion at page 2296 halfway down, that the conclusion of fact that the judge arrived at, namely that the sole object of the liquidation proceedings was to collect a revenue debt was amply justified, and he applied the revenue rule principles at the top of page 2297. Now, the reason I've gone through that authority with perhaps more attention than would otherwise be afforded to an Irish High Court decision is because it has been endorsed by the House of Lords in the Government of India case. And again, I anticipate that the court is very familiar with this decision, and so I can take it at some pace. As the court well knows, it's a claim by the Indian government to prove the company's insolvency in England to try and prove a debt due to the Indian revenue. The case can be found at page 1967 in the Principal Authorities bundle, tab 1. Bless you. And could we start, please, at page 1979 in the speech of Viscount Simons.
Simmons, I think you're right.
One sees...
Sorry, page.
Page 1979.
Thank you.
Viscount Simons, one sees in the ultimate paragraph expressing surprise to hear it being suggested that courts of this country would and should entertain a suit by a foreign state to recover a tax. And he then refers to a series of decisions culminating in re Visser, Queen of Holland, and Sydney Municipal Council Bull. And in essence, the Government of India's attempts in this case to either distinguish or disapply the revenue rule fell on unfertile soil. One sees at page 1981, in the middle of the page, the Lord Chancellor describing a formidable array of authority which had been deployed, and he says it's possible that the words "take notice of" might, if applied without discrimination, lead to too wide an application of the rule. This was based on the Holman decision of Lord Hardwicke and Lord Mansfield, which had perhaps been too wide, in particular in Holman and Johnson. But he then says, in re Visser, as Lord Tomlin pointed out in re Visser, there may be cases in which our courts, although they do not enforce foreign revenue law, are bound to recognise some of the consequences of that law, and for this reason the terms of Lord Mansfield's proposition have been criticised. But in its narrow interpretation, it has not been challenged except in 3 cases mentioned earlier in this opinion, and in them it was unequivocally affirmed. His Lordship then said, it's also recognised in other states, and he refers to Lord Somerville's research into French law. At page 1982 to page 1983, his Lordship rejected any suggestion that there should be some sort of weighing in the balance of whether a revenue law was a good law or not, or whether or not it was the sort of tax that would be accepted by this country. At the top of page 1983, he said he was little disposed to introduce so nice a refinement, i.e., is it the sort of tax that we ourselves would recognise, so that there's no public policy issue? That wasn't in fact the issue. And then finally, at the bottom of page 1983, a plea was made for the special relationship between the British Commonwealth, of which the Government of India formed part. We then find at page 1984, top of page 1984, second paragraph, I must add that since writing this part of my opinion, I have learned from my noble and learned friend Lord Keith that he has discovered a case in the courts of error which confirms the view I've expressed, and that's the Buchanan and McVeigh decision that Lord Keith cites and approves. His Lordship then says, we proceed upon the assumption that there is a rule of the common law that our courts will not regard the revenue laws of other countries. It is sometimes, not happily perhaps, called a rule of private international law. It is at least a rule which is enforced with the knowledge that in foreign countries the same rule is observed. And since it's a rule which operates equally in regard to natural and artificial persons, the company with which we are here concerned could not, on the day before its resolution to wind up became effective, have been sued by the Indian government for recovery of the tax. He then finds that the same principle applies if the claim is brought through the liquidators of the company. Page 1985, Lord Morton and Lord Reid concur. Lord Keith's speech begins at the bottom of page 1985, and at the top of page 1986, he agreed with the overall proposition derived from the speech of Viscount Symonds. Such additional observations as I make under this head are due to the fact that I have had access to a judgment delivered by Mr. Justice Kingsmill Moore in the Irish High Court on July 21st, 1950. And he then refers to it as an admirable judgment, illustrating two propositions. First, there are circumstances in which the courts will have regard to the revenue laws of another country. And two, that there are in no circumstances will the courts directly or indirectly enforce the revenue laws of another country. He then gives an explanation for the rationale for the revenue law at the top of page 1987. And two explanations are essentially given. The first is that the enforcement of a claim for taxes is but an extension of the sovereign power which imposed the taxes, and that an assertion of sovereign authority by one state within the territory of another, as distinct from a patrimonial claim, is contrary to all concepts of independent sovereignties. So, in essence, it's bound up with territoriality, territorial distinctions, and maintaining sovereignty within territorial confines. There's then a reference to another explanation, which is that adopted in Moore and Mitchell, which is the invidious position that the court may be put upon if it's asked to adjudicate upon the revenue laws of another state. And he says at the bottom of page 1987, on either of the explanations which I've just stated, I find a solid basis of principle for a rule which has long been recognised and which has been applied by a consistent train of decisions. Page 1989, we then find the speech of Lord Somerville. And his lordship, the first substantive paragraph of his speech says, the first issue in the present appeal is whether a foreign state can use the courts of this country for the collection of its taxes. He refers to Holman and Johnson. And over the page, page 1990, halfway down the page, he recognises that this decision is the first decision of the House of Lords dealing with the point, and points to the fact that essentially everyone had treated it as self-evident up until this stage. He refers then, in the next paragraph, to tax gathering being an administrative act through in settling the quantum as well as in the final collection. Tax gathering is not a matter of contract, but of authority and administration as between the state and those within its jurisdiction. He then refers to how that would work. And then, for completeness, at page 1991, he cites, in French, a decision, an academic treatise from the treatment of private international law in Pilet in a 1924 work. And without wishing to thrust my translation on the court, it essentially says a domestic court is not going to get involved in the execution of a foreign law, especially one that involves fiscal rights. Then says the appellant is asking the English courts to do what the courts of no other country have done. In some fields this might commend the argument, but here, for the reason which I've stated at the outset, it is fatal. That, my lords, is Government of India. Could we then please move on? I have two or three authorities to go to which simply endorse the fact that Government of India is good law, the first of which is Reed Norway's application. That's in principal authorities, page 2088 behind tab 5. 2088.
Thank you.
The facts are essentially set out in the head note. Norway's sought to have orally examined through letters rogatory two bankers in order to deal with a tax issue concerning an estate of a deceased person, in which it was said a tax debt was due. An initial request was too broad, dismissed as fishing. There was then a revised request that was made, and one of the grounds relied upon by the bankers to resist the application was that it would amount to the indirect enforcement of a foreign revenue debt or debt claim. Page 2172. The leading speech is given by Lord Gough, with whom their other lordships agreed. 2172, starting at subparagraph E, one sees an endorsement by Lord Gough at E to H of the underlying rationale for the revenue rule. Please could I invite the court to read those paragraphs. Turning over the page, at the top of page 2173, His Lordship inclined to support the view of Lord Keith that it was the sovereignty issue which was the better theoretical basis for the rule. And we see it, subparagraphs E to G, His Lordship declining to accept that simply by having two bankers orally examined by our courts, that was giving effect to a foreign tax claim. Indeed, he noted, I think, at some point that both the taxpayer, this was a response to an application by the taxpayer, and therefore it would be surprising if it were indeed a suit trying to enforce a tax debt by the tax authority in Norway. And then at the bottom of the page, 2173, he says, since the state, as well as the estate, is applying for the assistance of the English courts, it's necessary to consider the broader question whether the execution of letters of request in relation to foreign civil proceedings in a fiscal matter should, if the request is made on the application not of the taxpayer but of the taxing authority, be refused. And he said, I must confess to having given the most anxious consideration to this question. First, the rule is deeply embedded not only in the common law but also in the law of the civil law countries. An eloquent account of it is to be found, and he cites exposition by a French professor of the French principles. It then says, second, there appears to exist no case of fiscal proceedings in relation to which letters of request have been executed in any jurisdiction, and it can be argued that if a change has to be made, it should be made by legislation, not by judicial decision. He then referred at subparagraph D on page 2174 to the Government of India decision and said it is of importance to observe that the rule is limited to cases of direct or indirect enforcement in this country of the revenue laws of a foreign state. And in contrast, he did not think, see subparagraph F, that there would be any extraterritorial exercise of sovereign authority in seeking the assistance of the courts of this country to obtain evidence, even if it will be used for the enforcement of revenue laws of Norway in Norway itself. So the point that was being made there is, look, this is providing assistance by way of obtaining evidence, not for enforcing that tax debt in the United Kingdom, but obtaining evidence in the United Kingdom so that Norway can use that evidence back in Norway to enforce a tax debt in Norway. And therefore we say it's in no way a narrowing of the revenue rule, it's simply a non-application of the revenue rule. We next have a judgment of the Privy Council behind tab 6, starting at page 2178, in the case of Webb and Webb. Slightly complex facts, but essentially a Cook Islands resident was undergoing matrimonial separation, and there was an application made by the wife for a division of the matrimonial property. That was complicated by the fact that the New Zealand Revenue, see paragraph 6, page 2179, had made an assessment for a substantial amount of tax. And one of the issues was, should the matrimonial property be diminished by the value of that tax claim, which would in fact wipe out the benefit of the matrimonial property, because the tax claim was very large. More importantly for our purposes, there is a summary of the relevant principles given by Lord Kitchen, starting at paragraph 32. It's quite a long section, but to spare your Lordship's ears and my voice, please could I invite you to read paragraph 32 through to 37, which set out the key principles. They include a reference to Buchanan, but they then cite other authorities, which I'm proposing not to develop it, certainly in opening, because I say Lord Kitchen helpfully has developed the core propositions here. So that's 32 to 37. then at paragraph 39, his lordship said, there can, in my view, be no doubt that that the foreign tax principle, if applicable, would preclude any attempt by the New Zealand Revenue, a receiver or a trustee in bankruptcy, to enforce the judgment debt against Mr. Webb's assets in the Cook Islands. That had a double-edged element to it for Mr. Webb as the husband, because, see paragraph 41, if it were the case that he would have a defence based on the revenue rule to any attempt by the New Zealand authorities to assert their tax debt in the Cook Islands, it meant that those funds would be available for distribution as part of the matrimonial settlement. Lord Wilson disagreed with that principle, but didn't actually cover in his dissenting opinion the revenue rule for those purposes. I think before the short adjournment, if I can just try and deal with Williams and Humbert, which is the next authority in the relevant authorities that deal principally with the revenue rule in this jurisdiction. It's behind tab 7, page 2205. The facts broadly set out in the head note. The Mateos family, well-known Spanish family, involved in production of sherry and various other spirits. They had a series of companies, one of which was a Spanish company which owned shares in a Jersey company. And there was hiving off of certain trademark rights by the English company, W&H William and Humbert Limited, to a Jersey company. So there was a transfer by an English company owned by a Spanish company of trademark rights to a Jersey company. What happened was that the Spanish parent company was compulsorily acquired by the Spanish state, and when the company, the parent company, then sought to claim back those trademark rights because they'd been, according to its claim, unlawfully diverted to the Jersey company, the defence asserted that that would be giving effect to an unlawful penal law that had been enacted by the Spanish government, Spanish legislature, by way of effectively compulsory acquisition of the shares in the parent company. So it was a penal law case, not a revenue law case. That's the first point. And it was held by Lord Templeman in the speech with which the other law lords agreed, that the case concerned simply recognising the fact of compulsory acquisition. That didn't involve necessarily giving effect to that law, because the claim that was in fact brought was a corporate law claim by a company for a cause of action that had always vested in the company, and the fact that the underlying share ownership of the company had changed and was now owned by the Spanish state did not alter things. In Lord Templeman's speech, picking it up please, at page 2268, in the letter C, having cited a range of authorities, his lordship said, these authorities illustrate the principle that an English court will recognise the compulsory acquisition of a foreign state and will recognise the change of title to the property which has come under the control of the foreign state and will recognise the consequences of the change of title. He then concluded that since the company was bringing its own claim, this was not a revenue rule matter. One sees a citation at page 2269 of the Government of India principle, and his lordship says at letter G, in the present proceedings the Government of Spain are not parties to any action and no claim for taxes is in issue. So the revenue rule authority that was relied upon and cited, including the Buchanan and McVeigh case, weren't in point. And his lordship then said, page 2270, letter C, in my opinion, the Buchanan case only concerns a revenue claim. The principle that a country cannot collect its taxes outside its territories cannot be used to frustrate or contradict the principle that the courts of this country will recognise the law of compulsory acquisition of a foreign country of assets within the foreign country and will accept and enforce the consequences of that compulsory acquisition. So, in essence, this was a case in which the claim didn't require the court to express any view on the validity of the compulsory acquisition, because it was a corporate law claim brought by the parent company. None of that mattered. Now, Lord Mackay, at page 2276, and it's right to say that the other lords who did not give speeches also approved this speech as well. So to the extent that it contributes to the ratio of the case, it is a binding ratio. But his lordship, at the bottom of page 2276, cited a series of cases, Rossano, Brockau, and so on, to examine the nature and extent of the revenue rule. And then we see a summary given at letter D on page 2277 of the way that the defendant sought to develop the revenue rule defence. Counsel for the appellants had sought to derive a general principle that even when an action is raised at the instance of a legal person distinct from the foreign government, and even where the cause of action relied upon does not depend to any extent on the foreign law in question, nevertheless, if the action is brought at the instigation of the foreign government and the proceeds of the action would be applied to the foreign government for the purposes of a penal, revenue, or other public law, relief cannot be given. So it was a very broad construction of a principle of the revenue rule which in no way went that far, and that's in essence what Lord Mackay found. Paragraph H, he said, having regard to the questions before this House in Government of India, I consider it cannot be said that any approval was given by the House to the decision in the Buchanan case, except to the extent that it held that there is a rule of law which precludes a state from suing in another state for taxes due under the law of the first state. No countenance was given in Government of India or in Brockau to the suggestion an action in this country could properly be described as the indirect enforcement of a penal or revenue law when no claim under that law remained unsatisfied. And that's the proposition that my learned friend relies upon heavily in his case. The existence of such an unsatisfied claim to the satisfaction of which the proceeds of action will be applied appears to me to be an essential feature. Now we have, if we may, four short points in relation to that. Firstly, dealing with the revenue rule was not part of the ratio of the case. This is a penal law case based on compulsory acquisition. Therefore, the conclusions are obiter from Lord Mackay. We note it wasn't cited, for example, by Lord Kitchen in Webb and Webb. Secondly, in Dicey, Morris and Collins, page 2355, it's in no way treated as altering the revenue rule. It's given as an example of a situation where the rule against indirect enforcement of a penal law was not engaged. Third, as I've sought to indicate, it was a response to an overly broad formulation of Dicey Rule 20. It was a response to an overly broad formulation of Dicey Rule 20 by counsel for the appellants in that case. So they were taking the revenue rule and running with it, and Lord Mackay said that wouldn't work. Fourth, in any case, we say there is an unsatisfied liability here. What is that unsatisfied liability? Well, it is SCAT seeking to recover overpaid income tax that is being paid out through the refunds. And indeed, as I indicated in opening, if there is no unsatisfied claim, then we wouldn't be here. And it's the characterisation of that claim for recovery of overpaid income tax that lies at the heart of this case. And the difference between us, if I can put it this way, is my learned friend says this is a fraud. We say, well, that's your pleaded case, but it's a tax fraud.
Is the proposition of Lord Mackay correct?
My Lord, the American authorities suggest you don't need an unsatisfied tax liability as such, because the American authorities that I'll come on to after the short adjournment show you can have a claim brought and stopped by the revenue rule, brought by a state and stopped by the revenue rule, where there is a claim for lost revenue, for example, through smuggling operations, which doesn't depend upon identifying any individual tax debt. So it looks at the aggregate position of smuggling, the costs of smuggling, having to deal with smuggling operations, and the revenue the state would have obtained from excise duties on a cross-border smuggling operation for either alcohol or cigarettes. That doesn't depend upon identifying any particular unsatisfied tax debt.
So on that basis, are you taking issue with Lord Mackay's statement?
Well, we're saying it doesn't matter for present purposes because there
I
was...
understand you say that. I understand you say it's overture.
There are situations where the revenue rule would be capable of being applied without pointing to a specific unsatisfied tax debt. Yes. And those are identified in the US jurisprudence. None of...
You'll be coming on to them.
Yeah.
Yes. Would that be a convenient moment?
If that's convenient for you.
Thank you.